are. But I have received in the consumer arbitration process a waiver of fees because of my income. So I need to have that on the record and that people be aware of that.
Yes, sir. Those are two different things, but I understand the AAA and you decide what fees you pay. I'm not involved in that.
Okay.
Attorney's fees are a substantive claim in the case, and all I'll need you to do is by April 12th is tell Mr. Barnett if for some reason you don't agree that the amount of time spent and the rates charged were reasonable and necessary in the defense of any claims that are left in the case. If you agree, all you're doing is agreeing that's a reasonable number. I'll still make a decision as to whether attorney's fees are recoverable under the law. If you don't agree, then Mr. Barnett, one exhibit that you will submit at the hearing is your bills redacted for any privilege, and you can redact for privilege anything that you send to Mr. Crossett. But you'll submit your bills redacted for privilege that identify the amount of time spent and what for, and the rates that are assessed for each of those charges, as well as a reasonable pre-estimate of how much time you anticipate spending in the hearing. You'll just submit that as another respondent exhibit. Do you understand, Mr. Barnett?
I do.
Okay. At the hearing, before we close the evidence, Mr. Crossett, I will give you the opportunity to, and if you have an exhibit that explains why you don't think Mr. Barnett's, if and why you don't think Mr. Barnett's amount of time and rates are reasonable, you can submit your own exhibits as claimant's exhibit, and we'll talk about the attorney's fee issue at the hearing. The reason I want to do that is we're getting pretty spread out here on the time, and I want to be able to give you a decision consistent with the AAA rules within 30 days after we close the hearing, and I don't want to keep the hearing open for any reason just to receive attorney's fees. Okay, so, all right. If, Ms. Delvi, am I saying your name right, Ms. Delvi? Katerina? Delvi, I'm so sorry. With a last name like Halfan, it's important to me I get everybody's last name right. Okay. Correct me if I'm wrong here, but my understanding is, I do know if we proceed under the consumer rules, all communications will go through the case manager. Do we agree on that?
I agree to that. Yes, please.
No, sorry. I'm just asking the case manager for an interpretation of the AAA's rules.
It's up to you and the parties. It can either be direct exchange or through AAA.
Well, my understanding is when there is a pro se party under the consumer rules, it would be just through the case manager. But I also understand that if it's under the consumer rules, it can be direct exchange. In light of what Ms. Delvi has told us, let's just do that. Mr. Crossett, you have the burden of proof, so I'll let you go first. Mr. Barnett will tell us his thoughts. We have to have an agreement on this. We can either communicate through the case manager, or we can have direct exchange. Direct exchange means that the parties can communicate with me directly, provided that they always copy the other side and the case manager on all communications. Do you have a preference of how we communicate about this case?
Yes, I do.
Mr. Crossett?
Yes, I do.
What's your preference?
I prefer to go through the AAA. They seem to get it right. They seem to send it to everybody. I've not seen them make a mistake yet. And they also have accommodated me by reading to me the information, making sure that I got it, that my machines did not skip it. So I really prefer to go through the arbitration people, please.
Okay, Mr. Barnett, I will tell you that I think Mr. Crossett makes a compelling case for communications going through the case manager. Is that okay with you?
That's great with us.
Okay. All right, great. I think that that's probably, for reasons that Mr. Crossett elucidated, probably the best way to go. The parties should use the AAA web file electronic case filing method. You've been doing that already, right, Mr. Crossett?
Yes, sir.
Okay, and Mr. Barnett, is that okay to continue doing that?
Yes.
Okay. Let's talk about cybersecurity and privacy. Obviously, everybody needs to be careful to make sure that they maintain the privacy of people's communications. Generally, Mr. Barnett may know this, Mr. Crossett, you may as well, but since you're not a lawyer, I'll point out, generally, one of the rules of arbitration is what we do is essentially confidential. You're certainly entitled to talk about the fact that you have an arbitration with people. You're entitled to talk about information, but if you think you're going to need to share information that you received from Turo, through Turo's lawyers, with people, other people, then we need to know now, because Turo may ask for some kind of a confidentiality order. So, do you think you're going to need to share documents you get from Turo with anyone other than your assistant?
Well, when you say your assistant, I have several assistants, so I'm not quite sure what the question means. I certainly have people.
Read assistant as assistant or assistants.
Plural. I have several assistants who have access to this recording and to the information.
All right, let me just ask it a different way. Mr. Barnett, does Turo feel there be a need for a confidentiality order?
I'd like to see what the requests are that he propounds, but I think at this time, if there's an understanding that the documents will be kept within the arbitration, won't be shared publicly, and if Mr. Crossett needs to share documents with his multiple assistants who help him with this matter, I'm fine with that. But if we get to the point of time that something's being required to be disclosed that I think requires further confidentiality, I will raise the issue with Mr. Crossett and see if we can come to an agreement, and if not, we will come back to you.
Very well. So we do that often, we'll do that here. I'm simply going to say that the parties should confine the disclosure of information and documents exchanged in the case to the parties and those who are assisting them in the preparation for and presentation of the case. So Mr. Crossett, as Mr. Barnett said, if that's going to be the order. If you feel like you need to show this to your neighbor or some other person that isn't helping you in the case, but you feel for some reason you need to show it, then you'll need to let Mr. Barnett know that. And if he feels he needs to show it to somebody else, he's going to let you know your information. And then you all can either come up with an agreed protective order. I think the federal district court protective order in the state for the Utah district is quite good. I can tell you I litigate around the country as a litigator, and I often use the Utah federal district protective order. I think it works very well. But you all can come up with whatever you want. If you can't reach an agreement, then I'm going to tell you how we do everything that we do when we can't reach an agreement. But do you understand that plan, Mr. Crossett?
Yes, I do. And may I please ask this? I did not get an identification. I got the names of the people who are in this hearing right now, but I did not get the names of the law firms that they're representing. May I ask that, please?
I think Mr. Barnett and Ms. Merrill are with the law firm of Holland Hart. Is that right?
That's correct. We're the only people present right now in this room, and we're attorneys at Holland and Hart. We're the attorneys for Turo.
Mr. Crossett, if it helps you, I'm an attorney with the law firm of Lewis, Brisbois, Bisgard, and Smith. But I'm not working as an attorney in this case. I'm working as the arbitrator.
Yes, sir, I understand.
Ms. Delaval would probably...
And you're located in Salt Lake City, correct?
I am not presently sitting in Salt Lake City, but I have an office in Salt Lake City, yes, sir.
Okay, thank you very much.
Right. And Ms. Delaval would probably tell you she's not an attorney. Okay. And correct me if I'm wrong, Ms. Delaval, but okay. Lastly, before I get to resolving any disputes, you have my disclosures. I've made disclosures to the AAA. it is very important to the process, to the AAA, to the parties, and particularly to me, that everybody always understands that they have a completely neutral, objective arbitrator deciding this case. I've told the AAA the answers to any questions about my relationship to anyone in this case, which is zero. And I don't anticipate forging any such relationship during the life of the case. If somebody finds information that raises a question as to whether I remain objective and neutral, you should bring that to the attention of the AAA. It's an ongoing process. If I find something that raises a question about my relationship to any of the parties, the lawyers, anything like that, I will bring that to the AAA's attention. Since we're not using direct communication, you don't have to worry about that, because you would never email me about any question about new witnesses, new parties, any questions about objectivity. If you have any questions about that, you must send them to the case manager. The AAA resolves those. If they need information from me, I provide that information. I don't decide questions of my own objectivity. The AAA does that, so that you're assured that remains a matter of objective analysis in and of itself. But if anything comes up and you have any questions about that, Mr. Crossett, you'll direct those to the case manager. Do you understand?
Yes, I understand that principle. I do.
Okay. Mr. Barnett, Ms. Merrill, I assume you're okay with that?
Yes.
All right. Now, let's talk about the last thing on my schedule, but we're going to talk about anything anybody else wants that you all think helps us move forward. The last thing I want to talk to you about is motions. In the life of your case, which is about to span, looks like about 8 or 9 months, you may have some disagreements. It happens. The way we're going to resolve disagreements is you all are going to talk to each other. And when I say talk to each other, I mean actually talk to each other. Not emails, phone, if Mr. Crossett is amenable, video conference. If you all want to meet somewhere and sit down and talk, whatever you want to do, but before you ever bring a matter to my attention, you must have discussed it with each other. And I'm going to recommend that any discussion you have about anything on which you may have a disagreement, you approach it with a goal of compromise. That is, not I have to have everything I want, or I'm going to go to the arbitrator, and not you can't have anything you want, but rather compromise. Just a suggestion. I'm here if you can't reach an agreement, but what you need to know is if you don't reach an agreement and you bring it to me, I will make a decision, but one or both of you may wish that you had compromised. So think about compromise in trying to resolve any issue. Put another way, we have a macro problem, which is a dispute in this case. Better for both parties not to create micro problems along the path of resolving the macro problem.
I'm sorry, I don't understand that term. Would you explain that macro problem?
When we have an issue, I'm going to decide in arbitration. It may be one or more claims.
I
You
see.
may have minor issues that come up along the way, and I'm just going to suggest to you that you will probably be happier and they will probably get resolved quicker if you all work together to try to do that by agreement. Now, if you work together and try to reach an agreement, but you just can't, that happens, I understand, then whoever feels as though they need me to make a decision is going to write the case manager, and all you're going to say is, we have a disagreement and we need to have a conference with Bill. And we will pick a day, and we will pick a time, and we will have either a phone call, or Mr. Crossett, if you can accommodate it, we'll have a video conference. Either way, it'll probably be by phone or video conference, but maybe if we need to do it in person, we will. And we will sit down, and the party who thinks that you need my decision on something will explain what that is, and the party that disagrees will explain their position, and I will give you a decision. But no, don't file any motions, don't file any briefing. We don't need that. We're going to solve these problems as they arise based on the fact that you all have already talked about it, you can't do it, and we're going to talk about what the resolution will be during a conference. Do you understand, Mr. Crossett?
Yes, sir, I do, thank you.
Okay. Mr. Barnett, that work for you?
Yes.
Okay. Now, Mr. Crossett, you, I've noticed, have filed a number of things in this case, and you're free to file, but you need to understand, I'm only going to read things on the schedule that we've adopted. So, if there's an issue that comes up, instead of filing something, I want you to reach out to Mr. Barnett, and Mr. Barnett, same thing on the other side, instead of filing anything. And if we need to file something, we'll have a call, and if somebody says, I really need to show you something, we'll figure out how to look at that. But most of the time, we can resolve these things just by having a discussion. And so if you file something, either party, you need to understand, I'm not going to read it unless I've authorized filing a motion. Okay, you got that, Mr. Crossett?
Yes, sir, I do now, yes.
Okay, got that, Mr. Barnett?
Yes.
Okay, and the reason for that, just so everybody understands, is it's only fair if both parties feel that there's a need to brief something, and I agree, and then we set up a schedule for briefing with appropriate page limitations and time. So I'm not just going to read, and I don't mean this in a pejorative way, that if somebody decides something pops in their head and they want me to look at it, I'll read it as part of the preparation for and handling of the final hearing. If it's appropriate as part of a dispositive motion, you'll put it back in the dispositive motion. But we can't just have like, hey, something just occurred to me that I want the arbitrator to see. That wouldn't be fair to the other side. Okay.
Now, sir, may I ask
All right,
this
with all
question,
that-
one question, please? The case file that has been already created, have you read that case file?
I have read everything that is in the web file system with the AAA, but after today, I will only read new filings in the context of making decisions along the schedule that we've agreed.
I understand. Thank you very much, sir.
Because that would only be, the only way to be fair to you, Mr. Crossett, would be to say, I'm not going to read something Mr. Barnett files tomorrow. It's only fair to Mr. Barnett's client if I say, I'm not going to read something Mr. Crossett files next week. If you can file something, but it eventually will need to be brought into the context of the briefing schedule that we've already discussed.
No, I understand that. I appreciate it and I understand it. You're saying that basically the stuff, information that I've sent that is in the case file, you have reviewed to this particular conversation, and at this point, and from now on, Mr. Barnett and I are to communicate together, try to resolve things together. If we can't, then we can go to the arbitration board and say we'd like this to be able to be discovered and resolved.
Yes, sir. I think you said it quite well.
Okay,
Mr. Barnett,
thank you.
Does that comport with your understanding? Does that comport with your understanding, Mr. Barnett?
Yes.
Okay. All right. Now, with all those things in mind, everything we've discussed, Mr. Crossett, you have the burden of proof. Is there anything else you can think of that you think we need to discuss today in terms of scheduling or procedure that will help move things forward?
Yes. Your rules of discovery. I need to know what I'm up against. I have no information of why they fired me.
Mr. Crossett, thank you. I skipped ahead, and you're 100% correct. Let's put some framework around the 3 months we've allowed for discovery. And I'm so sorry. I'm so glad you pointed that out, because I might have had to get y'all back. All right. Mr. Crossett, you have the burden of proof, so I'm going to start with you. You're going to get disclosures from Mr. Barnett's client, and that's going to give you information about witnesses that he thinks he's going to call, documents that he anticipates using. So you're going to get that on October 9th. After that, thinking right now, do you anticipate the need to send written discovery in the form of interrogatories or request for production or request for admissions?
And you didn't say deposition. I'm not sure.
No, I'm starting with Mr. Crossett. Mr. Crossett, I know exactly what I said. I need you to hear what I said.
Okay,
Written discovery.
go ahead, please. I'm sorry I interrupted.
That's okay. Written discovery, that is interrogatories, request for admissions, or request for production. We're just on that right now.
And the question is, please?
Do you anticipate the need to send any of those things?
Yes, sir.
Okay. If you get their disclosures by October 9th, can you send your written discovery by October 23rd?
Yes, sir.
All right. Mr. Barnett, can you send your written discovery by October 23rd?
Yes.
No, I'm not even going to do that. Let's just say if I give you 45 days within that window, because we gave ourselves plenty of time, we're going to say all written discovery should be 45 days after the 9th. So let's see what that looks like. Because we've given ourselves plenty of time here. So let's October 9th, 7th, 21, 20, 28. I'm going to say 35 days. So, no written discovery after 11/13.
But does that say that after we're done talking, discovery is now open?
After October 9th, no discovery until after you get the disclosure.
Okay, I understand, sir.
Because you may not need to send the same discovery once you see his disclosure. Okay?
Yes.
I was going to suggest a shortened time for responses to discovery, but we'll just leave it at the presumptive 30 days. That is, Mr. Crossett, you'll have 30 days to respond to Mr. Barnett's discovery, written discovery. Does that work for you?
Yes, sir.
Okay. And Mr. Barnett, is that adequate to respond to Mr. Crossett's written discovery?
It is.
Okay. Let's put some limitations in here so it doesn't get too out of control on written discovery.
I'm wondering about 10 of each category.
I was going to suggest, so let's talk about them individually. Mr. Crossett, I'm not going to tell anybody they can't send requests for admissions, but I will tell you that in 39 years of practicing law, I have never seen an effective use of request for admissions, because I can't make a party admit something they don't want to admit, and I can tell you that if you and Mr. Barnett wish to stipulate to a fact, you can do that without the necessity of request for admission. However, I want to give you the opportunity, with that understanding in mind, I want to give you the opportunity to send request for admission so you feel as though you've had the opportunity. Is there any reason you anticipate sending more than 15 requests for admission?
15 and under is fine. Absolutely no problem, sir.
Okay. All right. Next. You're going to get, remember, in disclosure, you're going to get, by the way, Mr. Barnett, are you okay with 15 RFAs?
I prefer less. I prefer 10. I mean, I don't think they're helpful, but, you know, they can be helpful for very limited purposes.
Right. I tend to agree with you, but the difference between admitting and denying 10 versus 15 to me seems quite nebulous.
Yeah, fair enough. I'm just, we're going to wind up having whatever number we have for requests for production and interrogatories, so I'm just trying to not have the cumulative burden of the three categories be high.
I fully understand what you're saying, but I'd much rather fall on giving somebody the request for admissions they want than have somebody later say, if I could have just had these requests for admissions, it would have made a difference in my case. And again, I wouldn't presume for 1 second to tell you how to practice law, but I'm imagining, as I said, that the burden responding to 15 requests for admissions is not significantly greater than responding to the 10. So I'm gonna saddle you with that, with my most profuse apology. Okay. Let's talk about requests for production, Mr. Crosset. Remember, you're going to get Turo's voluntary disclosure of all documents that they have that they think are relevant to any claim or defense in the case. If that happens, then how many requests do you think you'll need to make for other documents besides the one that Mr. Barnett and Ms. Merrill think are necessary?
The number would be 10.
All right, Mr. Barnett, I think that comports with your suggestion regarding the request for production. Am I correct?
That's great.
All right. And then let's talk about interrogatories. So, Mr. Crosset, as you know, interrogatories are questions. They're going to be answered by one or more representatives of the company in your case. And if Mr. Barnett sends you interrogatories, then there'll be questions that you're going to answer. They're answered under oath, and they can be used as basically the equivalent of testimony at the hearing. Obviously, they got to be in context. But with that in mind, and understanding that you've already told us that you might want to take a deposition, one deposition or more, how many interrogatories do you think you might need to send?
The number would be 12.
Okay. Would you need to send any more than 12 interrogatories, Mr. Barnett?
No.
Okay, then we're going to go with 12. Again, with apologies to Mr. Barnett if he thinks it should be 10. And I'm not being flippant. I understand your goal of limiting, but I think that's the difference again between 10 and 12 is not worth arguing. All right, let's talk about depositions. Mr. Crosset, you may know this, but I want to be clear, depositions are testimony under oath. In the case of a company, you can ask the company to designate one or more people to testify on matters that you must identify in advance, and that would be in accordance with Rule 30b-6 of the Federal Rules of Civil Procedure. I can't remember, it's also 30b-6 or 30b something in the state rules. But if you're going to take a deposition of Turo, which may be one or more people from Turo, once you tell Mr. Barnett the categories of deposition topics, he will designate one or more people to answer those topics, about those topics. Do you anticipate the need to take more than one deposition in this case, based upon what I just described, Mr. Cross?
My answer to that question is I don't anticipate having to take more than one deposition, but this isn't my first rodeo. Basically, if the person they produce comes up with I don't know, or I didn't bring that document, we're wasting everybody's time. So I would like to reserve the fact without implying any kind of dishonesty or lack of good faith. 3 depositions. I think it can be done in one if it's done correctly and done right, but if it's not, I want to reserve the right to bring up 2 more depositions to fix any kind of deception.
Well, here's what we're going to do. We're going to make a schedule based upon the presumption that everybody does this the way they're supposed to. And again, Mr. Barnett is a litigator, and I imagine he's arbitrated before. He understands what a corporate representative deposition is and how to prepare one or more people to do that and how to present those people. Is that a fair way to say that, Mr. Burnett?
Yes, I understand the 30B6 rules.
Okay, and Mr. Crossett, to address your hypothetical concern, and I'm not diminishing it, but it's hypothetical right now.
Yes,
There is a mechanism of resolving a problem if the problem that you have suggested does arise, and you can look at how to resolve that in the law, but I'm just going to tell you a shortcut, which is, if you take a deposition of Turo and you give a list of Mr. Barnett of topic A, topic B, and topic C, and they bring a person and that person says, I know everything about topic A and everything about topic C, but I know nothing about topic B, then you work with Mr. Barnett to get either another person or for that person that Mr. Barnett brought to learn about topic B. But we have to enter a schedule with the presumption that Mr. Barnett is going to do this by the rules, and he knows the rules, and I think he would agree with me that the rules say he bring somebody, and if they don't know, then they either bring somebody else or the person who doesn't know finds out what they need to know. Is that your understanding of the rules, Mr. Barnett?
Sure, yes.
Oh, great. So I'm not going to plan for failure, Mr. Crossett. If a problem arises and Mr. Barnett says it's okay that that person doesn't know and you don't think that's okay, then you're going to go through our problem-solving process, which is you'll talk about it. If you can't reach an agreement, you'll let the case manager know. So if you're going to take the deposition of Turo, and if we assume for just a moment that Turo is going to comply with the procedures that we've discussed, which Mr. Barnett has confirmed, will you need to take, do you presently have a knowledge of a need to take anybody's deposition other than Turo?
other than Turo's employees?
Yes, sir.
No, I have no plans of taking a deposition of anybody other than Turo's employees. However, I'm still very uncomfortable with putting the burden on me if a company hides the ball, they play games, they take advantage of disadvantaged or blind people. I would compromise this. I would take the corporate person, assuming Mr. Barnett will be faithful and in good faith, but I'd like to have the possibility of a second deposition of an employee.
Well, here's what we're going to do. Again, we're going to set. Let me look to Mr. Barnett for a second. Mr. Barnett, do you anticipate the need to take any deposition other than perhaps Mr. Cross's?
Yes.
Okay.
I think it's. Do you want to know more, or do you want me to be quiet?
I just want to know nothing. I want to know a number. How many depositions do you anticipate potential for taking?
Well, I don't know how many aides Mr. Crossett has that have assisted him with this, so I can't answer that fully. And I believe that there are probably 2 individuals at least who were Turo guests who interfaced with Mr. Crossett, but I need to find that out a little bit better through the discovery process. And I might be interested in taking their depositions as well, because that's relevant to the termination.
Okay. Well, let me say 2 things. First, I'm going to set the limit at 3. If you all find that there's a good reason to expand that, work together, see if you can compromise. If you can't, you'll let me know. Somebody can explain to me why there should be more than 3 depositions. I should point out again that unlike litigation, well, even you all are young people, but there was a time even in litigation, and there certainly is still the time in arbitration, that it isn't necessary to take every potential witness's deposition in advance of the hearing. You can call people and talk to them. You can get statements from people, all the things that you think you might need to prepare for the hearing. But I also understand you may need to preserve their testimony. So I'm going to set the limit at 3. That's a lot for an arbitration like this, but again, I want to be deferential to what the parties think that they need. So Mr. Crossett, if you find you need to take more than one deposition, the limit will be 3, subject to you all agreeing to do more. If you agree to do more, then you can do more under terms that you agree. You don't even need to let me know as long as it's working along the lines of an agreement. If somebody thinks they need more than 3 and they can't agree, then you'll reach out to the case manager and tell her you need to meet with me to talk about that. Does that work for you, Mr. Crossett?
Yes, sir. Thank you very much.
Okay, can we start with that, Mr. Barnett?
Yes.
Okay, super. Let's talk about a limitation on the amount of time for a deposition. I won't be at the deposition, but I am trying to save the parties time and money, which is, again, an essential part of arbitration. But I'll defer to y'all. Mr. Crossett, how much time do you think, for the one deposition you know you're going to take, you think you're going to need on the record questioning the witness?
Give me about 6 seconds to think, please. I would say somewhere between 4 and 5 hours.
Okay. Mr. Barnett, do you have any anticipation of needing more than 5 hours for any one deposition?
No, and I'd like to suggest a shorter limitation. I think 3 to 4 hours would be appropriate for party depositions, and I think we could have a shorter limitation for non-party depositions.
All right. Again, I'm
trying to keep this efficient.
I totally understand, but because Mr. Crossett is maybe not as experienced in taking depositions, I'm going to give him the 5 hours for party deposition. Again, I understand where you're coming from, but I do want to be sure that Mr. Crossett has the ability to develop the evidence from Turo. And we're going to limit non-party depositions to 2 hours, unless Mr. Crossett, you tell me there's some reason it needs to be longer, and then I'm going to flip to Mr. Barnett and hear from him.
I can agree to that, no problem, please.
Mr. Barnett, will 2 hours for non-party depositions work for you, or do you need more time?
That's sufficient.
Great, okay. Now again, listen, folks, right, you be the reasonable people that you're being today, right? So, Mr. Crossett, if Mr. Barnett is questioning somebody, and it turns out he's at 1 hour and 59 minutes, and he says, I need 20 more minutes, I'm not going to tell you what to do right now, but just think about whether it might be okay to let him have the additional 20 minutes rather than having to come back to me and try to reschedule all that. Same thing on your side, Mr. Barnett. I'm sure the parties will do that. Try to, I don't know, you all, again, I don't know if anybody's ever read Robert Fulghum's book, Everything I Needed to Know I Learned in Kindergarten, but
Yeah, I did.
the other one is,
I did. It's a good reference. It's a good legal reference.
more lawyers would do better to read that book, but just Reverend Fulgham's first point is try to put yourself in the other person's position and just think, how would I feel if I were here, and would I want that person to do me a favor? Okay, all right, Mr. Crossett, this is why I won't stop until everybody's told me that they've addressed everything. You reminded me of the importance of addressing the nature of discovery. So that will be in the scheduling order. Thank you for doing that. Now, having addressed that, Mr. Crossett, since you're the party with the burden of proof, anything else that you can think of that we need to talk about that would be helpful to moving things forward?
Well, I'm not sure if this is appropriate at this time. I asked and invited opposing counsel, Mr. Barnett, directly about mediation, and I was willing to go to mediation. I think we judge people on their behavior, not on their words. And Mr. Barnett said, if you're not going to take $5,000 or $10,000, we're not interested. There was no further comments from there. So I am open to mediation. I don't know if you're able to order it. I don't know if you need to put it on the record. I try to get along. My behavior and my resume show that. I'm not defending an indefensible position, and basically I am willing to go to mediation. But if Mr. Barnett says the numbers are not worth our while to go to mediation, then he has that right and he has that privilege. But he has to be responsible for that behavior.
Sure. Let me say a couple things about that. First of all, I didn't hear the numbers, and I don't care about the numbers, and I'm never going to pay attention to numbers. And no one should ever tell me about numbers that they're discussing about the potential for resolution of this case, because it's not something that factors into decisions I have to make. So I think you might have mentioned some numbers. If you did, I didn't hear them, and I'm not paying any attention to them. Second, I think the question of whether the parties should go to mediation is committed to the parties. I do know that some arbitrators will order arbitration. I think that again, in terms of the time and money-saving goals of arbitration and the self-determination that arbitration allows above and beyond litigation, suggests to me that I'm just not that arbitrator. I don't order people to mediate. I highly recommend that the parties think about alternative ways to resolve this dispute, because there are some decisions coming up in the dispositive motions and not in the dispositive motions, in the question of arbitrability, in the question of what did we say, arbitrability, as well as
Which rules should apply?
right, as well as the commercial versus consumer rule selective. I couldn't read my handwriting there. That may make people happy or unhappy. And so you should think about whether you want to take more control over this case by reaching an agreement. You are welcome to negotiate directly. You don't necessarily need a mediation. But if one party thinks a mediation will help and you can persuade the other party that a mediation will help, then that's up to you. But I'm not an arbitrator who normally who orders people to mediate. Because, Mr. Cross, and just simply because I'm responding to your suggestion, there's no value in me telling Turo and Mr. Barnett and Ms. Merrill to go mediate a case if they're going to sit with a mediator and say, we had no desire to be here, we're just here because the arbitrator said we had to be here, and then the mediator says, well, if they're not willing to do anything, he can't or she can't make them do anything, and I can't punish them because they chose not to settle a case, nor would I if I had the authority. Whether to settle a case is up to y'all. I believe the best resolution to a case, and I believe this both as an arbitrator, as an advocate, and I sometimes serve as a mediator, is the one that the parties negotiate. But I also recognize, having been in the dispute resolution business for just under 40 years, sometimes you just aren't going to reach an agreement for whatever reason, and somebody has to make a decision. So you should talk to each other about mediation, but I will not order a mediation in this case, at least not on anything I've seen right now. If circumstances change and somebody thinks there's a compelling reason the arbitrator should order mediation, you're welcome to bring that to my attention. I'm not foreclosing discussing that down the road, but I just don't think that's really the arbitrator's place.
Thank you very much. I understand. Thank you.
Anything else, Mr. Cross?
Let me have 9 seconds, please.
Take the time that you need.
I want to emphasize again, if I could please, and make it clear, that because I'm in a power wheelchair and I'm transported by UTA Transit here in Salt Lake City, I need to give them 2 or 3 days notice of the hearing, the place of the hearing, and when to drop me off and when to pick me up. And I want the situation to be overt and obvious, that I need accessible wheelchair access to a hearing area that is convenient and is reasonable. If the arbitration is way over across the other side of Salt Lake Valley, I may be stuck on a transit for 2 or 3 hours. That's not fair. I don't agree to that. So we need to have the arbitration building convenient and able to be accessed by the transit authority people. And that's why I've indicated that I would be willing to pay for the Bountiful City Hall. To me, that's neutral, and that is also close to where I live, that I would not need that transportation. I could reach that by my own wheelchair. So just let that be on the record, please.
Yes, sir. I heard you, and again, I'm not minimizing what you said. I've set a location that accomplishes all of the things, that, as far as I know, accomplishes all of the things that you described. You're going to get the order. We are many months away from the hearing. You are welcome to check with whomever you need to check, UTA, private assistance, anything like that, that they can survey the location. If you want to send somebody or you want to come and look at the facilities, you're welcome to do that. If you find, for any reason, that what I'm offering to you is not workable versus just not necessarily desirable, then talk to Mr. Barnett. And if you all, and again, you don't even have to come look at the facilities or anything like that. If you hang up the phone here and you call Mr. Barnett and he agrees to do the Bountiful City Hall or some other facility that you all agree on, you'll just write me, do the case manager, and say, we have mutually agreed that the hearing will be on the same days we selected at this location. But I would ask simply keep an open mind, and because if you have a dispute and you and Mr. Barnett cannot agree, you're going to have to come back to me along the lines of how we discovered how we solve problems. And if that happens, I'm still going to have to make a decision. And so that's not to say I'll hear everything that you want to tell me. I'll hear everything Mr. Barnett wants to tell me. By that point, Mr. Barnett may have reasons why he's checked out the Bountiful City Hall, and I'm just guessing here. I'm not saying I know this, but maybe he's checked out the Bountiful City Hall and he's found out they don't have this or that or the other thing that we think we need for hearing. So work together. But I think if you want to come by the office and look, you got several months. If you want to send somebody else by, whatever, you want to check with UTA, whatever you need to do, you're welcome to do anything you need to do, and I'll be happy to accommodate you. I'll have somebody meet you and show you around, or whoever you send. But let's not presume a problem. Let's deal with a problem if and only if one arises, and then if and only if you all can't reach an agreement on how to solve it.
Yes, please. Would you mind then putting your name and address on the recording so that if I want to visit, I could do that, please?
Sure. My name is Bill Helpan, and my office address in Salt Lake City is in the Mill Rock area. It's Mill Creek area. It's 6550 Mill Rock Drive, second floor. The zip code is 84121. If you feel like you or someone on your behalf, or you and someone else, want to come look at what facilities we would be using for the final hearing, you just need to send the case manager an email. The case manager will notify me. Mr. Barnett will know about it as well, and I will give the case manager, you can tell the case manager the proposed date and time you'd like to do that. If it works, I will give the case manager the contact information for the receptionist, and you and anyone you wish to bring are welcome to come. Mr. Barnett and Ms. Merrill are welcome to be there to ensure that the only purpose of that meeting is to look at the lay of the land, as it were. There'll be no discussion about the case. I will not likely meet with the parties at all if you come by just to look at the facilities, just to make sure that we're not getting into the merits of the case. But
That's excellent. Thank you very much. I appreciate that.
Sure. Okay. Now, Mr. Cross, anything else that we haven't covered that you would like to, that you think would be helpful to moving things forward?
the only question I would have now is, what is going to happen from this point forward? The last information I had was that there had to be Zoom, which I can't use. But do I just sit now and wait? Where are we in the process as far as me getting communication from you or the arbitration board again?
Later today, or perhaps tomorrow, no later than Friday, you will get from the case manager the scheduling order that we've discussed that sets out all of our deadlines. And you will see in writing, or will have the ability to have it, I guess, read to you through your system, all the deadlines that we have, all the plans that we've just made. Then the case is in your hands and Mr. Barnett's hands, and you should follow the deadlines that we've set out to move the case forward. There are times where you will see in the scheduling order that I will owe you a ruling or a response, and I will get you that by sending it to the case manager in plenty of time to get it to you by the date that I promised to give it to you. Does that answer your question?
Yes, sir, it does, and I'm done. I feel that I've been treated so far very fairly. You've been transparent. You've been honest at this particular point, and I compliment you that you're accommodating me in a way that I can actually present my case on its merits. Whether I win or whether I lose is irrelevant. But I appreciate the accommodation, and I have nothing further.
Thank you. I appreciate your saying that. You are correct in perceiving that that is everyone's goal here, is that everybody have the opportunity to present, to collect, and then present the evidence that they think helps us resolve the dispute if it requires a decision by the arbitrator. So thank you. It's very kind of you to say that. If you ever feel that's not the case, at least let the case manager know, because everybody wants this process for both parties, and Mr. Barnett, of course, is invited to do the same. Everybody wants this process to provide ample opportunity for the parties to make their presentation so that I can make a decision based upon the evidence in the law. All right, thank you. Mr. Barnett, it's your turn. Anything we haven't talked about or that you think we need to talk about further that will help the parties move